I'm Gary Venner, Managing Director of IFA Acquisitions, and I'm joined by Alex Cannon, Partner of Herrington Carmichael, where we continue our informative question and answer series under our YouTube channel to provide top tips when selling an IFA business and an insight into the legal processes when buying or selling an IFA business by two industry experts. The title of the next video is coming up on screen now. Alex, financial services companies have a unique set of issues, I suppose, from other industries, particularly around that sort of complex payment mechanism from recurring income, which is of course governed by Financial Conduct Authority rules. What's your involvement in assisting sort of the process of making sure that this is all covered in contracts?
So the key thing for us when we're looking at the payment structures is clarity. Making sure that it's very clear what you're getting paid, how you're getting paid it, and when you're getting paid it. And the concepts of recurring revenue and EBITDA or funds under management are quite subjective, I've learned over the years. And I think when you see different buyers, they categorise things differently. Different sellers categorise differently, and we see a number of different variations of what fundamentally everybody thinks they're talking about the same thing. So when it comes down to looking at the purchase contract, one of the most important things is making sure that you've got clear definitions that talk about recurring revenue or EBITDA or whatever the adjustment basis is for your transaction. Now, when we talk about recurring revenue, there's lots of different kinds of things like old-fashioned trail that people sometimes say are excluded, but actually a lot of sellers are expecting them to be included because that's how they value the business and put figures forwards initially. So for us, actually having that conversation early on and making sure that it's clearly set out is important. Similarly, from an EBITDA perspective, making sure that you're very clear about what adjustments will apply. As we all know, profit can be manipulated in 101 different ways, so making sure that you've got clarity on what sort of adjustments and add-backs might apply. And I think that's particularly important if you are dealing with a buyer who has sort of private equity backing, because we tend to see EBITDA being used more frequently with those sorts of buyers than say sort of smaller industry buyers. Now, where funding is being raised by the business, obviously there's finance charges and things that can apply within the various different companies that are being bought. So for a seller's perspective, making sure that they're very clear how or what, if any, of that is being shared by them and what impact that could have on their purchase price calculation is critical. So at the outset, one of the first things we look at when we are reviewing effectively a purchase contract is looking at that payment structure, because that is what's going to be ultimately key to the seller and what is driving them to have got to that stage in the transaction.
That sounds fantastic and reassuring to vendors as well, that somebody like yourself has that experience and making sure that they're well protected in the clauses as well.
Very much so, and I think the other thing just to sort of add around the payment profiles and things as well is making sure that there's a level of reasonable protection in the purchase contract as well. So when a buyer takes over the business, they are effectively in control. So they have the ability to move clients around their group potentially. They have the ability to potentially even sell clients on and resell them. Yeah. So making sure that your sales agreement puts appropriate restrictions around that, so that your calculation, which if it has a variable element, isn't effectively manipulated to your disadvantage as a seller, is important. And making sure that where you've got a situation where clients can be moved around a group, or where the buyer plans to consolidate your clients into another entity, that the definitions are suitably broad to make sure that it captures all the revenue from your clients that goes into the buyer's group rather than just into the company that it does at the moment.
That's reassuring to know. We talked earlier about the length of time the FCA are taking these days on change of control, and how AR appointed representative agreements are sort of being used more now than they were before for sort of post-sale. What's your sort of experience of drafting those? And I hear the term SUP 12 of the FCA handbook. What does all that mean?
So appointed representative agreements are used in a variety of different structures. We see buyers who will acquire directly authorised firms, deauthorise them and make them an appointed representative of a central directly authorised entity, as much to clean up that structure as anything else. We also see some structures where firms are being asked to deauthorise before sale and then become an appointed representative at the point of transaction. But appointed representatives are effectively relying on their principal firm's permissions. So a directly authorised firm appoints another firm to act on its behalf and in its own name under an appointed representative arrangement. Now, from a transaction perspective, appointed representative agreements need to be put in place if those structures are being used at the point of sale, so that everybody knows what the parameters are, making sure that it's compliant and making sure that if there's any fees and things that are going to be due within that sort of structure, that it's clearly set out. Similarly, from a regulatory perspective, making sure that it's a compliant agreement is important. So you mentioned SUP 12. The key thing there is that is effectively a section of the FCA handbook which sets out a list of specific requirements that all appointed representative agreements have to comply with. So as part of drafting any agreement, there's making sure that it complies with those requirements and that they're sufficiently sort of clear so that if challenged or inspected, that it was pass muster with the FCA.
Well, that sounds absolutely fantastic, Alex, and I'm delighted that you know your stuff so well on that, and particularly around the SUP 12, which it does lose me at that
It's not
point.
for everybody, but yeah.
Exactly. Subscribe to our YouTube channel and switch on notifications so that you won't miss our next video in this series of top tips when buying or selling an IFA business, and an insight into the legal processes by two industry experts, me, Gary Venner, MD of one of the UK's largest specialist brokers in IFA Acquisitions, and Alex Cannon, partner from Herrington Carmichael, who are leading commercial lawyers specialising in IFA mergers and acquisitions.